Today in this video we are going to discuss about the second appeal in Civil Procedure Code 1908, and first we have seen the first appeal, which is coming under section 96 order 41, and this is coming under the section 100 to 103, 107, 108 and order 42. So the first appeal lies on the rehearing of the degree passed by the court, and naturally the aggrieved party can approach the higher court to re-examine the degree passed by the lower court. So likewise, when the first appeal, the failure party or the person who the verdict given against the person can approach for the second appeal in the high court. That is the second appeal. The procedure, the litigant, the aggrieved party can go for the second appeal in the higher court. Is called litigant or the appellant. So the section 100 allows filing of second appeal in high court. So basing on the merit of the question of law, that is substantial question of law, that is substantial means substantive right. It has to establish the substantive right of the person. When the right of the person is infringed, then when there is a substantive right in the appeal, he can go for the second appeal. That is the meaning. That is, the High Court is satisfied that the case involves substantial question of law, but substantial question of fact need not be there. But in certain cases, it also sees the substantial question of fact also, but rarely. But main question of thing for the second appeal is the court should feel that there is substantive question of law is there, then, but not on any other ground. Even when the ex parte degree is passed, he can go for second appeal, but not on any other ground. And what is substantial question of law is very, very important to decide the merit of the second appeal. That is said as it is a sine qua non. That is, sine qua non means that is the deciding factor. Without that, it cannot be proceeded. The admissibility of case or further proceedings cannot be taken up. That is called sine qua non, without which it cannot be proceeded. That is called sine qua non. So we have to see the substantial question of law. The substantial question of law that is based on 12 factors to determine what are the substantial question of law. One is called a question of law having a material bearing on the case. So the material bearing should be there in the case. And second thing, a question of law gives scope for a conflicting opinion or judgment. When there is a conflicting opinion or judgment, then there is question of law. And the third thing is a question of law which is not covered by any specific provisions of law. And then the fourth one is a question which affects substantive rights of the parties. So when the substantive right means the rights of it may be the right to speak or right to property, like that. That is the right of the persons. If it is affected, then that is there is the question of law. Then a question relating to misinterpretation of degrees. Then A question of placing onus of proof on wrong party. When the onus of proof is given to a wrong party, there is question of law. Then the second appeal lies. Then the question of general public importance, a question of admissibility of evidence, and a question which involves that is debatable, fairly debatable legal issues. When there is fairly debatable legal issues are there, that is called question of law, and that can be taken up for second appeal. And a question which calls for a discussion of alternate views. When alternate views also there is question of law, and that can be taken up for second appeal. Like that, a question relating to an issue what is not free from difficulty, and a question which is not covered by settled legal principles or proceedings. When it is not coming under the already decreed, is not coming under the settled legal principles or the settled legal precedents, the second appeal lies. So these are all the question of law, substantial question of law. You should have the substantial question of law, then only the matter can be taken up by the High Court under section 100. Now we will see the section 101 and 102. There is no second appeal lies in certain cases. That is, no second appeal lies in any suit when the subject matter for the recovery does not exceed 25,000. So when the money recovery cases, if it is not exceeding 25,000, then it cannot be taken up. If it is exceeding 25,000, then the second appeal lies. Then when the subject matter involves other issues, the second appeal is maintainable. When except the money matter, when the other subject matter is other than money recovery, it is applicable. It can be the second appeal lies. And section 103, the power of High Court to determine the issue of fact. So it is the court should decide the issue of fact. Second appeal, if the evidence on record is sufficient. So the second appeal always lies when the evidence on record is sufficient. When the evidence is sufficient, then it can be taken up. If the court feels that it is sufficient. And then section 107, power of appellate court. What are the power of appellate court? Then power to determine case finally. So it is the court to decide the case finally, and power to remand a case. When the remand is required, it has the power to remand a case, and the power to frame issues and refer them for trial. If the subject matter is there, if the issues are not framed, the High Court has the power to frame issues and refer them for trial, and power to take additional evidence. So according to section 107, additional evidence also can be taken up. And now we will see the section 108. According to section 108, the procedure in appeals for appellate degrees and orders. From for the appellate degrees and orders, section 107 gives provision, that is, from appellate degrees and orders under this code or any special or local law in which a different procedure is not provided. The cases can be, the appeals can be taken up from appellate degrees. When the degree is clearly mentioned that it is appellate, then it can be taken up. And the appellate orders are there under this code, then that can be taken up for appeal. And apart from that, if there is any special law or any other local law, special law means, for example, prevention of SC Atrocities Act, like that POX Act. So these are all called special acts. Like that, local laws are also there, in which a different procedure is not provided. So when different procedure is not provided, that can be in special law and local law, that can also be taken up in second appeal. Then a case study for this substantial question of law, Gujarat Agro Industries Company Limited versus Municipal Corporation of the City of Ahmedabad and others, 1999, Section 468. That is, appeal cannot be decided merely on equitable grounds, but lies only on substantial question of law. So in this case, it has been decided that the substantial question of law should be there and not on equitable grounds. Then the last, the Limitation Act. Limitation Act specifically, though limitation has not been fixed in Code of Civil Procedure, in the Limitation Act, Section 116 clearly specifies that the within the all the appeal can be should be made within 90 days from the degree, from the date of degree. That is the Limitation Act specifically says under Section 116. So with this we conclude this video.